Panel is a panel on public corruption called Better to Give Than to Receive, prosecuting and defending bribery and corruption cases post-McConnell. We've got a great group up here, and I'll introduce these guys in further detail as we go forward. But we've got Hank Asbill from Jones Day in D.C., my colleague Bill Matea from Polsinelli in Dallas, Jack Sharman from Lightfoot in Birmingham, and Adria Perez here in Atlanta, Kilpatrick Townsend. At last year's program, we had a similar panel dealing with public corruption, and Hank was on that panel as well. And the day of the discussion last year was following the Supreme Court's decision in United States versus McConnell, and literally right before Hank took the stage last year, he got the call from the Department of Justice indicating that they were not going to be seeking a retrial and that the case was over. Which was very interesting timing for Hank and the program. And in the months that have followed since the McConnell decision, there has been a number of cases, particularly in the Second Circuit, where they've attempted to grapple with the sort of evolution of honest service. So, by way of background, as you're all probably very familiar, the public corruption cases are typically prosecuted by the government through 1346, which is the honest services fraud statute, which we have come to know, which discusses the deprivation of intangible rights. But before that came about, the primary hook for the government was Section 201, which was a federal bribery statute. And it talked about receiving anything of value in return for being influenced in the performance of any official act. Now, that last little phrase, I think, is going to be discussed in great detail as we go forward, particularly what is an official act? I mean, that's something that I think still remains to be seen. But what we really have been struggling with is that there never was a definition for what the difference between the political norm of trading favors and a criminal act done in exchange for personal gain. And I think that's something that you'll see as each of the panelists discuss their experience in this area. But sort of going into the Wayback Machine a little bit, I think McNally is the sort of seminal case on this issue in 1987, where the court really started to grapple with whether intangible rights can be prosecuted as a crime. And it was really in response to McNally that Congress passed 1346 as we currently know it today, which is, for the purposes of this chapter, the term scheme or artifice to defraud includes a scheme or artifice to defraud another of the intangible right of honest services. And so it was no longer sufficient for these public corruption cases to be charged through the typical mail and wire fraud statutes, but there was a new vehicle which has evolved, particularly in the last, 30 years now. Following McNally, one of the next seminal cases had to do with the Agricultural Secretary Michael Espy. In that case, is United States versus Sun Diamond Growers of California. And in that case, the company was charged with violating Section 201, the bribery statute. And the facts of that case, the company was alleged to have been given gratuities to Secretary Espy while he was considering matters in which Sun Diamond had a vested interest. And of course, we all know what happened at trial. There was a conviction, unfortunately, like there often is. But that case was appealed and ultimately went, and it was reversed, and it was affirmed by the United States Supreme Court. And ultimately, the holding in that case was that the government must prove a link between a gift and a specific concrete act. So it wasn't enough to have, by way of circumstantial evidence, the fact that a public official received a gift or gratuity, and in the course of his capacity or her capacity as a public official took some official action. And I think that's when we really started to see the narrowing of 1346 and different interpretations by circuit courts and the United States Supreme Court. Another case flowing forward from that was Skilling. And I think we're all familiar generally with the facts of that case involved the Enron CEO, Jeff Skilling, and charging him with conspiracy, securities fraud, insider trading, and honest services. And one of the issues in that case was the application of the honest services fraud statute to private conduct. You know, this is not a public official, it's a private individual. And for those of us here in the 11th Circuit, you may remember the case, United States versus DeVector from the late 90s, which involved, I know Bruce Malloy remembers that one well, and it involved the application or the attempted application of the honest services fraud statute to a private individual who made a recommendation to the Fulton County Commissioners, and through a political process, they decided on what they were going to do, but unbeknownst to the Fulton County Commissioners, Mr. DeVector was allegedly paid a consulting fee by someone who had a vested interest in that case. And allegedly. Isn't that res judicata at this point? That's right. So that's sort of the background, you know, of where we are today and kind of how we got there. And so, you know, I think at this point I want to talk a little bit about Hank's case and Governor McDonnell, and for those that don't know, as I mentioned, Hank is a partner at Jones Day in Washington, D.C. He's successfully defended individual and corporate clients for, I think, almost 4 decades. He's a fellow of the American College of Trial Lawyers, has got a number of high-profile cases that he's involved in, but for purposes of today, we want him to talk to us a little bit about the McDonnell case. And
these were payoffs. People are giving money all the time. People make contributions. The key difference here is that the contributions didn't go to a campaign. The money that came in went into his pocket. That's not normal politics. That doesn't happen every day.
You want to take the money out of politics, then take it out of politics. But this is not unique to Bob.
McDonnell's attorney, Hank Aspel, admitted the evidence in the case looked bad, but he said it's just the way American politics works.
You know, would anyone look at the gifts and loans in this case and say it's a good idea? No, I wasn't happy about having to defend it, but there was no crime.
But shouldn't we expect our politicians to have a higher standard?
Maybe so, and there ought to be a better way of reforming politics in America, as usual, than going after my client and accusing him of committing a crime which he didn't commit.
It gives much greater room for public officials to commit improper acts, to commit bribery in subtle ways, and it gives them that room to do it without worrying about getting prosecuted.
so Hank, with that as a background, and for those that may not be quite as familiar with the background of the case and the procedural history, if you could sort of, walk us through what happened and sort of some of the takeaways that you view from that case.
I'll try to summarize that in brief order. I've got a lot of takeaways in my mind after thinking about this for the last year. But in any event, McDonnell was prosecuted for allegedly committing 5 official acts, prosecuted under honest services fraud and Hobbs Act statutes, extortion under color of official right, neither of which seemed to me to apply in the case. But in any event, we argued repeatedly to the government prior to the indictment being brought and after it was brought that none of their supposed official acts were really official acts under the statute and should not qualify as official acts because basically nothing was ever done for the donor other than give him access to government. McDonnell hosted events, invited this donor to a cocktail party that was undersubscribed by 150 people. 300 people could come to the party, only 150 people signed up to show up. No remarks made at the party, etc., to favor this guy's product or whatever. In any event, the donor claimed to have a product that he thought would reform economics in Virginia during the Depression or during the recession in 2008 going forward. He supposedly could turn tobacco leaves into a healthy product and save Southwest Virginia from economic devastation. And it was a publicly traded company. And the guy was trying to get his product approved by the FDA ultimately. It was a supplement that was not yet approved, but in any event, it allegedly held out great promise for the economic future of the state. He became a friend of McDonald's of sorts, gave a lot of plane rides to him during the campaign and contributed money to the campaign, and thereafter had discussions with McDonnell about trying to pitch his product to state government. Basically what McDonnell did was give him access to people in state government for this guy, Johnny Williams, to sell his wares or try to promote his product. And the instructions of the clear message to all the people in state government who worked for the governor, Commissioner of Health, for example, others who met with Johnny Williams, was make up your own mind about whether or not the guy's got anything worth buying. I'm not asking you to do anything for him other than to listen to what he has to say. If it's a good idea, great. You guys are the experts in the health field, not me. So exercise your own independent judgment and make whatever calls you want to make. But I'm not telling you what to do or asking you what to do in terms of making a final decision. The government thought that that was enough to prosecute McDonnell under those two statutes because McDonnell was getting gifts, loans, et cetera, for himself and his family from this donor. He got $120,000 in loans that were repaid at commercial rates and were available to him at commercial rates at the time. He got a couple of vacations, a couple of golf games. His family got some stuff, and his wife got some stuff that her husband didn't know about. Totaled about $175,000. But in return, the donor got zip, got nothing, got not a dime from state government. Got no legislation, got no tax relief, got no board appointments. All of these were things that the donor wanted, and he got none of them from McDonnell. And McDonnell had many ways to give this guy something through economic development grants that he alone controlled, and could have done a myriad of things to help this guy out if he really wanted to do something for him other than provide access to government, which McDonnell felt was his obligation as governor. And you may, if you have some understanding how politics works, basically, in the governor's office, the governor basically is supposed to say, yes, I'll get you a meeting with somebody on my staff, and the staff is supposed to say no after the meeting if they don't think it's a good idea. But this is basically the way politics works, or certainly the way it worked in Virginia. And at the time in Virginia, there were no state laws that proscribed the amount of gifts or loans that a governor could receive from any particular individual or company. And historically, the preceding three governors in Virginia had all taken gifts, loans, vacations, et cetera, in an amount equal to the total that McDonnell took, albeit not from one single donor. But they'd all taken gifts or loans in the amount of about $150,000 or $200,000 during their four-year terms as governor.
Were you able to get that into evidence? I'm curious.
No, we're not able to get it into evidence. We tried, and we had an expert witness that the judge ruled out because he didn't want to let us bring that in. But we could not get, we fought like hell to try to get in evidence, but we couldn't. So in any event, that was the stage here for honest services fraud and for Hobbs Act. I never understood the Hobbs Act count because it was extortion under color of official right, which basically means, to me at least, that if you don't do something, there are going to be consequences for not doing it. If you don't give me a gift or a loan, I'm going to hurt you in some way. Zero evidence of that at all. In terms of honest services fraud, obviously that had been restricted post-Skilling, post-McNally. That also was a difficult issue for us to defend. because as you'd expect, good faith is a defense to any kind of fraud charge. Good faith defense to fraud, obviously, but that was not something that the court would permit us to argue officially.
Did the court ultimately give it a jury instruction on good faith?
Yeah, it gave a jury instruction on good faith that was limited to statements made in good faith are not actionable or not criminal, but he didn't expand it to say conduct done in good faith is not actionable. Ironically, there were 13 counts or 11 counts in the indictment, 2 of which were false statements to banks. On the false statements to banks, where the good faith defense instruction literally applied, the governor was acquitted. But the court would not expand that instruction to include conduct done in good faith as a defense to the fraud charges or the Hobbs Act charges, as opposed to the bank fraud charges. So in any event, we fought like hell about the jury instructions both before and after the trial, and told the government that we thought they were way off base, and that if they proceeded, that ultimately, no matter what the jury did, no matter what the Fourth Circuit did, that the Supreme Court was going to reverse this conviction if there were one, 9-0. We were wrong by one person because Scalia died. And I think if Scalia had lived, the statutes would have been invalidated to begin with, because they're overbroad and vague. And no matter how much the court encourages the government to cabin over aggressive legal theories, they don't seem to get the message, which is something I want to talk about at the end of this program, because it continues to this day in other contexts, both in political corruption and in other types of cases. But in any event, ultimately the court decides, the Supreme Court decides that an official act, to be an official act, it's got to meet a two-part test. And basically the two-part test is that the question, matter, cause, suit, proceeding, or controversy involved must involve a formal exercise of government power similar in nature to a lawsuit before a court, a determination before an agency, or a hearing before a committee. In contrast, the government's theory was, because McDonnell ran on a platform of Bobs for jobs, trying to resurrect the economy of Virginia after the recession, that was a sufficient hook to bring these kinds of charges. And the court further clarifies that the question, matter, cause, suit, etc., must be specific and focused, and something that is pending on an agenda, for example, before a public official. So the idea that the action, and then you have to basically pressure or advise, knowing that your advice is going to be followed. So you tell the subordinate, basically, I'm advising you to do this, and you know the subordinate is definitely going to do what you tell them to do. Or you pressure in some way that person to take this action on behalf of the donor. That is what the Supreme Court says was required. In McDonnell, there was not a single witness who ever said that he or she felt pressured by the governor to do anything other than listen to the guy and make your own independent judgment about whether he's got something worthwhile for the state of Virginia. But not a single person ever testified that they felt pressured by the governor to do anything other than to give someone an audience, which is exactly what politicians are supposed to do for constituents. And this was true from McDonnell in a variety of different contexts, not just rich donors, but poor miners in Southwest Virginia. There's nobody that asked for an audience from McDonnell that didn't get put together with someone who could deal with that person's concern. So in any event, the court basically rejected all our challenges to the instructions, gives an instruction to the jury that essentially directs a verdict in the case against us, and allows the jury to basically go off on all these theories that we thought were infirm from the start. They do that. The jury comes back after the verdict and is interviewed by the press and says in interviews with the press, basically, we asked ourselves whether or not the governor would have gotten the gifts of the loans if he had not been the governor. And if that were the test, we were dead on arrival. But that is exactly what the instructions essentially said to the jury, and that's what the jury, in essence, went off on. We go forward. The judge will not give us a new trial after that. We go forward further with the Fourth Circuit. The Fourth Circuit rejects our position as well. We do get bond for the first time in 40 years since the Bail Reform Act in the Supreme Court. And I knew then that we had won. And then the court obviously grants cert in the case and overturns the convictions, and it's remanded to the Fourth Circuit for the Fourth Circuit to make a determination about whether or not the government thinks it can pursue the case under the correct instructions and still possibly get by Rule 29. After a couple of months of screwing around with that decision, on September 8th of last year, the government makes a decision, and I get a call from Maine Justice at this program, literally 5 minutes before the start of the panel, that they have decided to dismiss, walk away, it's over, it's done, period. And that was the end of the case. Ironically, the client is having a party tomorrow night in Washington, D.C. to reprise the "it's over" decision on September 8th. So I will be back in D.C. in time for that cocktail reception tomorrow night.
Thanks for having me, folks. When Brian called me about 6 to 8 months ago to see if I would come out for this, I'm like, absolutely, because I've always felt like I'm kind of an unofficial Georgian. I worked for Larry Thompson. I'd walk into his conference room, and we always had meetings every day that he was in town. And you'd walk in, Chris Ray was there, who I think a lot of you all know. Paul Murphy was the chief of staff at the time. Chris actually hired me to come in there. And when you walked in, the portrait, and let me back up, the Attorney General, the Deputy Attorney General, and the Associate Attorney General, they get a chance to put a portrait up in their office, and you get a chance to pick a former Attorney General. And so Griffin Bell's portrait always hung, and I know a lot of you all know of Griffin Bell. And, Larry, during meetings, he'd kind of look up every now and then, and words to the effect that, what would Griffin Bell do at this time? And on top of having peanuts in the conference room, it felt like I was an unofficial Georgian. But I am a Texan, and I will say this. Barbecue in Texas is a lot different than the barbecue last night, okay? So you guys may know your sweet tea, but in Texas, we know our barbecue. It's one of the 5 essential food groups of barbecue, chicken fried steak, Mexican food, steak, and tacos. So I'm going to talk a little bit about kind of what's going on with the Paxton case, but I want to back up just a little bit and talk about political prosecutions in Texas, because we always joke in Texas about our neighbors to the east in Louisiana, that's where all sorts of political prosecutions go on. The truth is that now that I've got into the Paxton case and I've really looked into political prosecutions in the past, there's as many crooked politicians in Texas, as many prosecutions in Texas as there are in Louisiana, but they get a little bit more notoriety. But in Texas, it is true kind of blood sport. And what we see a lot in Texas is that political adversaries, they use their friends that are in the DA's offices, special prosecutors, to get cases indicted, to get people kind of out of the way. And we've been trying to send this message subtly in the Paxton case, and we finally kind of got vindicated about 2 weeks ago. The Wall Street Journal actually came out with an article, an editorial about the Paxton case. And if I can read it just real quick, because I like it every time I read it. Texas has a history of politicized prosecutions that attempt to destroy careers only to be thrown out of court. Think Tom DeLay and Rick Perry. The latest target is Texas Attorney General Ken Paxton. And on inspection, the evidence and legal process against him so far look equally dubious. So, and I'll let you read the other paragraph to yourself. But when that editorial came out, which just kind of came out of the blue, it was like, wow, people are paying attention to what's going on in our case right now. I can only hope that I'm as successful in our trial that's coming up in December as you were at the end of the day. So against that backdrop, I'm going to digress for a second and talk to you just a little bit about political prosecutions in the state of Texas. Before 1978, while there certainly were political prosecutions that were focused on various high-ranking officials. There weren't near as many that happened since 1978. So the Texas Public Integrity Unit is run out of the Travis County, which is where Austin is at, out of their DA's office. Now, while most of Texas is either moderate Republican or conservative Republican, in Austin, it's very Democratic, okay? And so generally that office is kind of more Democratic leaning, and we've seen lots of prosecutions, as we're going to see, of a lot of Republicans. Not always Republicans, but a lot of Republicans nonetheless. Ronnie Earl, who's in the middle, was the fellow who led that. And I want to just point out for a second the female to his left, your right, is Rosemary Lemberg, who became the DA in Travis County. She's going to be an important figure in the Rick Perry prosecution for reasons that I'll talk about here in just a second. Just real quickly, the first big case out of that unit was the Gene Jones case. He was a Texas state senator. Next case, this is the case that I remembered because I had just moved to Texas. I had graduated from Notre Dame. I had come back. My folks had moved. And then this was big news in Texas because whenever you indict the sitting attorney general, usually that's a pretty big deal. Ultimately, and he was accused of basically threatening to do harm to Fulbright and Jaworski because Fulbright wanted to interview his sister in connection with the case, and that's a gross oversimplification of the matter. He ultimately was acquitted a couple years later. Next case that I'm going to kind of call out is somebody who I think most of you all probably recognize, but Kay Bailey Hutchison was a U.S. Senator for at least 2 terms. At the time when she was indicted, she was the state treasurer. Next case, you probably never heard of Eddie Denton. And for every one of these slides, there's probably 4 other slides I could have thrown up of just people. But the whole point here is that there's a lot of political prosecutions. And in Texas, it seems like the genesis for a lot of this is political adversaries saying, you need to go after this person. So Tom DeLay, prime example of that. I mean, truthfully, as a result of the state prosecution, even though he was ultimately acquitted after it went up to the Court of Criminal Appeals, which is our highest court, it essentially ended his career, being the majority leader and in the House of Representatives. Rick Perry, the most recent example before Ken Paxton. And what's interesting about this case is Rick Perry is the governor of Texas. He basically said, I am going to veto funding for the very unit that we've been talking about, the Public Integrity Unit, unless you get rid of the DA, who at that time had been charged with DWI. And his position was very clearly that somebody that's been charged with DWI, who it appeared was guilty of that conduct, didn't need to be running the DA's office, and he certainly wasn't going to fund that office. And so basically, he got indicted for that case. Ultimately, the Court of Criminal Appeals throws that case out as well. And then kind of walks the very next case, which is the case against my client, Ken Paxton. So in a nutshell, the case that we've got right now with Ken is that the case was indicted a couple years ago. The genesis for it, and there's nobody in the press here, I understand, so I can talk a little bit more liberally, but one of his political adversaries that was his opponent in to get the Republican nod to run for Texas Attorney General, went to the Texas State Securities Board and said, hey, look, he was actually soliciting clients on behalf of an investment advisor. He's an investment advisor representative, and he wasn't registered with the Texas State Securities Board like he needed to be, because there's a statute that makes it illegal to not register as an investment advisor representative with the state of Texas. And so as a result of that, the Texas State Securities Board looks into it. He gets a lawyer very quickly. He's in the middle of the campaign. He wants to take care of this very quickly. And so he enters into a disciplinary order, a $1,000 fine, and a reprimand, okay? And an understanding from the Texas State Securities Board that they were not referring that, because the Texas State Securities Board never refers just simple failures to register unless it's part of a larger Ponzi scheme or something along those lines, okay? So, and I want to come back to that point here because it goes to one of my lessons learned from this case. As a result of that, Democrats jump on this. They file a complaint with the Travis County, the District Attorney's Office and the Public Integrity Unit, because the criminal statute reads the same as the civil statute that makes it illegal to not register an investment advisor representative, and actually makes it a third-tier felony under Texas's system. And so he essentially, by virtue of entering into the disciplinary order, some would argue that he essentially basically consented that he violated a criminal statute as well. Put aside intent, because you have to have intent and knowledge over on the criminal side, which is not necessarily true over on the administrative, but over on the civil side. So as a result of that, people start kind of coming out of the woodwork, and one of his political adversaries, again, Texas is kind of a two-party state, moderate Republicans, conservative Republicans, Ken had gotten incredibly crossways with a very powerful state representative who was in an informal investment group with him. And that person then goes to the SEC and complains that Ken had brought an investment opportunity to the group because they traded opportunities all the time. And that Ken, while he brought the opportunity to the group and everybody made the decision whether to invest based on their own due diligence, and these are people who are incredibly sophisticated, net worths, easily in the tens, if not hundreds of millions of dollars, and who, quite frankly, Ken looked to for advice on other opportunities, because Ken, in the big scheme of things, didn't have that same level of sophistication. Not that he's not sophisticated. But this individual, this representative, goes to the SEC, complains, and says, hey, look, we all invested in this stock. It's a company called Servergy. And again, I'm being a little more liberal in my remarks than I normally would if the press was here. But Ken didn't tell us that he wasn't going to invest in it. And oh, by the way, Ken also, after we invested, got 100,000 shares of stock in the company. Okay? And we think that's improper. We think that's fraudulent omission. The SEC runs with the case. But the state runs with the case before the SEC does. They indict that case in one indictment. They indict another case for the failure to register as an investment advisor representative in another indictment. The SEC, about 6 months after those indictments, then files a civil action against Ken. To make a really long story short, we were able to beat back the SEC case. Matt Martins, I don't know if some of y'all know Matt, terrific lawyer at WilmerHale in D.C. Matt was part of our team. Matt handled kind of the SEC side, did a terrific job on that part of the case. And while we've been able to beat back the SEC case, unfortunately, the same exact charges, which are pending over in the state case, there's not a motion to dismiss vehicle like we have over in federal criminal, federal civil and federal criminal. And so we're going to have to go try that case. But again, you get a flavor for this case is all about political adversaries. In one case, conservative Republicans going mano a mano with moderate Republicans. I think that's, kind of the nutshell of the case. We're going to try this case in December. And I'll show you a slide here in just a second where we're not really sure if we'll try it in December because, as many of y'all know, Harvey hit. And that has wreaked a lot of devastation down in the Houston area. But before I show you that slide, let me just say there's a couple things that I've taken away from the work that I've done, not just on the Paxton case, but I also represented Matt Blunt, who some of y'all may remember was the governor in Missouri. There was a political patronage investigation where Bud Cummings, who was the U.S. attorney out of the Eastern District of Arkansas, actually came in because the two U.S. attorneys in Missouri recused. But through my work on that case, and also I was involved in the grand jury investigation for Alphonso Jackson, who was the former Secretary of HUD. A couple things that I'll just kind of throw out there. This is more pertinent to Paxton, but particularly important to what we're talking about here today, and it's what I call, what is the quid? Okay, remember quid pro quo, okay? Even though in Paxton's case there's not really a quo because he's not charged with any kind of bribery, it's important to understand what the quid is when you get these kind of political corruption cases, because there's all sorts of collateral consequences for whatever it is that you label the quid, okay? What do I mean by that? Is it a gift? Is it compensation? Is it campaign contribution? Whatever it ultimately becomes in the position that you stake out on that, because again, as we all know, facts are not always black and white. They're very gray and they're very fluid, okay? But if it's a gift, in Texas, for example, there are anti-gift laws. There are ethics commission's disclosures. If it's compensation, there's tax implications. There is as well on the gift side. But there's also securities ramifications, because if it's compensation, is it transaction-based compensation that might deem you to be a dealer under the securities laws? Is it a campaign contribution? If it's in Ken's case, remember he got 100,000 shares of stock. I should have prefaced this. You know, there's issues that relate to the ethics laws and gifts as well. So it's really important to have thought 5 steps ahead on the quid, okay? This is always going to be applicable to all cases, but it's something that I just look at a lot of these cases preparing for today. Thought this might be something really important to talk about. The other thing is what I call the second takeaway is kind of look before you leap. And what I mean by that is that political corruption cases move at warp speed. They move at a pace that's faster than the normal cases that all of us here work on day to day. You know, politicians, they basically work from news cycle to news cycle, which is almost a daily basis, okay? When something happens, many times those politicians that you represent, they want a reaction that day, okay? They want, you know, point, counterpoint. And sometimes the best thing that you need to do in a case is really not do anything. But that's not what your client expects sometimes. And in this case, a prime example of looking before you leap, kind of a violation of that rule, was over on the, this is before I got into the case, I'll preface it, but when the Texas State Securities Board came knocking and said, hey, we have this complaint made, and we're looking into it, and the decision was made very quickly to go ahead and enter into a disciplinary order with the $1,000 fine and the reprimand, which then led to the criminal prosecution, which then led to the SEC getting involved in the case. The truth was is that had they have looked closely, and I'm telling you at one of our defenses it'll be a trial, but everybody knows this, is that the investment advisor that he worked for, it had just registered with the state, and if you may remember back when Dodd-Frank was passed, investment advisors with assets under management under 100 million needed to shift from federal registration to state registration. His investment advisor made that shift, but did not terminate its federal registration. So at the time that Ken solicited the clients that are at issue in our case, it was still federally covered. And under the Texas securities laws, if you're a rep of a federally covered investment advisor, then you can't be found guilty of not registering as an investment advisor representative. And hence, he really didn't need to enter into the disciplinary order. But expediency was key. They wanted to try to get this, turn it into a non-issue before things kind of exploded like wildfire. So again, look before you leap. The next thing, kind of a takeaway, is what I call stay on message. So in my Paxton case, I work with his political PR team, at times his official attorney general PR team. We have our own PR team. There are others that are part of his kind of kitchen cabinet who are also somewhat spokespersons for him. He is a spokesperson himself. His wife speaks quite a lot, and she just announced yesterday she's running for the Texas Senate. And I've got to keep all of those people on message, okay? It wears you out. I spend more time on that side of the case than I do on the X's and O's of really lawyering the case. But what I learned early is that you've got to put your foot down early, that the criminal team is driving the message, okay? You draw a very clear line with whatever office it is that that person is in, whether it's the AG's office or Senate, that they're not going to even touch on this. And you need to educate all of these people about all of the different ramifications, everything from your bar card and ethics obligations to what the judge expects, because every judge is different in terms of gag orders and what they expect that the lawyers can say in the press. And then make sure they understand that basically all the things they say can be bulletin board fodder for the prosecution in these cases. So stay on message. The last point I'll just mention is that it's incredibly important in your motion practice to recognize that everything you file will be magnified tenfold. and everything that you put in there is going to be analyzed backwards and forwards. So say what you mean what you say, and you're going to have to live with it. Proof like crazy, because little mistakes that you make can become bigger mistakes, and they may seem like minor typos, but all of a sudden they get magnified. So in any event, so that's what I've got for you on the Paxton case. I'm going to leave you with this slide, which this is a picture of the criminal courthouse in Houston as of last week. And so the entire first floor was flooded. I mean, it had 5 feet of water in it. Every toilet in the courthouse backed up. And so the entire state criminal courthouse in Harris County is moved to about 4 or 5 different facilities. Very unclear whether or not we're going to be trying our case in December. And I will just say, I mean, the entire state, civil and criminal side of Harris County it's going to be really interesting to see what happens. Basically, there's no criminal stuff going on until October. The civil side, basically nothing's going to happen until November. The federal side is basically unaffected by and large, but just in case you wanted to know.
In the few minutes that we have this morning, I want you to listen to the stuff about sex, but I want you to pay attention to the stuff about power, sort of come for the sex, stay for the power. Robert Bentley was a 70-year-old dermatologist in Tuscaloosa, Alabama, a deacon of the First Baptist Church of Tuscaloosa, and one of the more unlikely candidates for governor in recent Alabama history. One of his senior advisors was a woman named Rebecca Mason, a married woman, not his wife. Governor Bentley and Mrs. Mason began a relationship. Diane Bentley, First Lady of Alabama, and Governor Bentley's wife of 50 years, discovered the relationship and was displeased. Ms. Bentley's chief of staff was a young woman named Heather Hanna. Football fans among you will remember Heather Hanna's uncle, John Hanna, a longtime All-Pro lineman in the NFL. Heather Hanna showed Mrs. Bentley how to use her iPhone to record conversations between Governor Bentley and Mrs. Mason, and Mrs. Bentley did so.
I stand behind and I put my own jewels and I put my hands on those and I put my hands on it was including real close. I love that too.
There is more, but I will spare you. Governor Bentley also turned out to be an inept user of text messaging. He provided to Mrs. Bentley his state-issued iPad. What he did not fully appreciate was his iPhone was synced to the iPad, such that text that he sent to Mrs. Mason went simultaneously and immediately to Mrs. Bentley. That is difficult to read. Governor Bentley's comments are on the right in blue, Mrs. Mason's are on the left and gray, and at one point, Governor Bentley says, "Poor Robert, poor Rebecca," referring to themselves, and Mrs. Mason responds with a phrase that is now chiseled into Alabama political history: "Yes, bless our hearts and other parts."
That's great.
Governor Bentley became aware of the existence of recordings, and over time, this developed for him from a concern to something approaching an obsession. He suspected correctly that Heather Hanna was at the root of this problem. Heather Hanna testified that the governor threatened her on more than one occasion. What became interesting to us, though, as special counsel to the House Judiciary Committee, was not so much the relationship, but Governor Bentley's use of law enforcement in order to recover the tapes and minimize personal and political damage. He began using law enforcement, including the chief of his dignitary protection unit, which is sort of the state version of a Secret Service detail, a man named Ray Lewis. The photograph that is on the screen is from an election night celebration in Tuscaloosa, where on the mezzanine level, Governor Bentley was speaking with Ray Lewis, the chief of the dignitary protection unit, and celebrants for the election victory were down on the floor, and the governor and Mr. Lewis were looking at them. That was a news photo that just happened to be taken at the moment that Mr. Lewis was telling Governor Bentley that he, Mr. Lewis, believed that Heather Hanna was the source of the problem and actually had just pointed her out to the governor on the floor. But the misuse of law enforcement was what took this from a question of a sometimes unappetizing affair to something that might be an impeachable offense. The governor, among other things, sent state troopers to shake down current and former staffers, and he attempted to create a special investigations unit within ALEA, the Alabama Law Enforcement Agency, to see if a criminal case could be established involving Heather Hanna. Articles of impeachment were ultimately passed in the Alabama House of Representatives. The House delegated to the Judiciary Committee, a standing committee, the obligation to serve as an impeachment committee, and that is why I and my Lightfoot colleagues were retained. We began impeachment hearings on Monday morning, April 7th at 10 a.m. There was a parallel special counsel investigation. A special counsel had been appointed by the Alabama Attorney General. There was also a parallel Alabama Ethics Commission investigation. By 4 o'clock that afternoon, Governor Bentley had pled guilty to 2 criminal misdemeanors and had resigned office. So, all of that is entertaining, and as a lawyer, it's a lot of fun. There are some parallels, some things in common with a normal corruption investigation, and there's some things that are different. In the interest of full disclosure, one of the governor's lawyers, Bill Athanas, is in this room. He might have a different take on some of these things. But some of the similarities, I think there are 3, and the main differences, I think there are 3. First, both in an impeachment proceeding and in a standard public corruption investigation, you're dealing with a public official. So ideas and concepts of accountability and honesty and transparency come to the fore, both for the prosecution, so to speak, and for the defense, more than they might otherwise. Secondly, both tend to involve parallel proceedings. From our perspective, that is to say, from the House Judiciary perspective, we had virtually 0 contact with either the special counsel's office, that is to say the criminal investigators, or the ethics commission investigators. Everybody really rode their own boat. And then thirdly, in both a public corruption investigation and in an impeachment proceeding, the narrative is extraordinarily public. It is something that many of us are not accustomed to in normal litigation. Speaking of narrative, about a third of you are not listening to me anyway and looking at your phone, so go ahead and do this. We created a website called bentleyinvestigation.com as an effort to gain some control over that narrative. It was remarkably effective. As was mentioned earlier, there are restraints, ethical and otherwise, in litigation about the use of those kind of tools, but I commend it to everybody. And then three differences in closing, I think. First, if you think a federal statute is clumsy, try impeachment. It is a crude, necessary, but crude constitutional instrument. Secondly, it is not just legal, it is constitutional, and it takes place in sort of a political cage match environment. And then thirdly, an impeachable offense need not be a criminal offense, although many crimes are usually considered to be impeachable offenses. And figuring out, and then if you're a legislator voting on, or if you're a lawyer advising legislators, suggesting how they might vote upon what is an impeachable offense is even more intriguing than trying to figure out what an official act is. There's a lot more to say about impeachment, but I'm going to leave it there for the moment.
Audrey, one of the cases that I mentioned that I think is reflective of the changing theories from the government perspective is the Menendez case.
No, that's right, Brian, and it's hard to follow those text messages. I'm still thinking about bless your heart. That's really changed the definition for me. But I have to say that that's a good segue to what I was going to say about the Menendez case. So Brian's right. I do a lot of corporate internal investigations, and I defend our clients before all sorts of authorities. And I have been before public integrity of the DOJ many, many times. And I've seen sort of this pattern that we have here where, number one, it's the friendship defense. Well, I was really friends with that person, Audrey. That's why I took them to the Super Bowl, or that's why we went to that great lavish vacation, right? I have to tell you, in all the FCPA work I do, no one ever gives me the friendship defense when it comes to FCPA. So that either tells me that our politicians are incredibly friendly in this representative democracy that we have, or that somehow our politicians are able to quickly get that relationship with these corporate employees to their benefit. The second thing I've always seen, too, is just the amount of gifts. Just from the lavish vacations, the sporting events, the Olympics, the Super Bowl, the division championships, if it's baseball. There's always something like that, and we see that in the Menendez case as well. And then the third thing I was going to say is attractive women who are not the wives of the participants, but you kind of beat me to it, Jack. I can't tell you how many times.
Bentley did.
Well, he did. He did. Bentley did. There's always attractive women involved, which of course is in the Menendez case as well. And then the fourth thing, obviously, that we all deal with every day is poorly worded text messages like that one, emails, all of that, expense reports, all of that always comes into the case or the matter, and that's what you see in Menendez. So I've heard, and Brian has told us, and Hank has too, about how this conference always seems to be spot on when it comes to timing, and especially with McDonnell last year. This year it's spot on when it comes to timing with regard to the Menendez case. I mean, it's been 36 years since a sitting senator has been the defendant of a corruption trial, and it just started on Tuesday. Of course, you see the headlines, and Menendez says, well, we're good friends. We have a friendship. The government doesn't understand friendship. And so that's what's going to be really interesting here after McDonnell is, are we talking about friendship or are we talking about official acts? And now we have a narrow definition of what official acts is. So the other thing to keep in mind with Menendez is you have an ophthalmologist who lives in Florida, who has lavished, Senator Menendez with private jets to his villa in the Dominican Republic several times. He paid for Menendez's trip to Paris in a lavish hotel. He's given him money to his campaign. He's given money to a legal defense fund that Menendez supported. So they have a long-standing relationship. There is no doubt about it. And so it's going to be interesting to see as they're fighting over jury instructions right now about how do they get, how are they able to convince the court and the jurors, right, of what an official act is and whether Menendez has done something to influence others in the government. So what the government is saying, the prosecutors, is that Menendez took all these gifts and benefits and then he helped Mr. Melgen in basically three ways. The first way is that Mr. Melgen, outside of being an ophthalmologist, he's a Renaissance man. He also has a contract with the Dominican Republic government to provide servicing at ports. It's an exclusive contract. He's had some issues with the Dominican government, so he needed some help from the State Department, and he asked Menendez to help him. So Menendez actually met with the State Department several times, sent some emails to the State Department several times, and the prosecutors believe that those meetings and those emails show him exerting influence as a senator to the State Department officials, telling them to help his friend. The second one has to do with the attractive women. Even though Mr. Melgen is married, he's had several girlfriends who are not from the United States or residents or citizens of the United States, so they needed visas. And so he asked Senator Menendez to help him get visas for his girlfriends. And so Senator Menendez told his staff, can you please help me out and direct the appropriate authorities to help me get these visas and get them quickly for my friend. And then the third one has to do with allegedly that Mr. Melgen, in part of his ophthalmologist practice, that he had defrauded CMS of $9 million, over billing, of course. And so he needed some help from Senator Menendez to actually reverse a decision from CMS about that. And so, again, that's all part of this whole sort of story, the soap opera. And you can see we have a lot of soap operas to talk about. That the prosecutors are trying to show the jurors that this guy is not just setting up meetings, he's not just providing access, that Senator Menendez is actually influencing other government officials, which is a little bit different from McDonald, I would say. So the other thing, too, is that we talked about how there's a fight over the jury instructions. And apparently it's become quite contentious. I was reading this morning that there was a new article about how even the judge had to tell both sides to shut up. Like literally had to say, shut up.
I think it was actually just to the defense attorney.
Yeah, so because it was just too much, right? It was just too much going on with the back and forth of arguing about these jury instructions, but also other things that the defense wanted into evidence. So it's going to be really interesting to see how this plays out as time goes on.